Oh, welcome back. Now that we've talked a little bit about who I am and we know how it is that you and I can best stay in contact with one another, are you still kind of wondering what's going to happen in my criminal case? Well, in this video, that's exactly what we're going to learn about, which is how does this criminal process work and what can I expect to happen at my pretrial conference? Well, now the first part of this process is behind you. You had your initial hearing. That's the hearing where the judge went through the government's allegations, went through the minimum and the maximum penalties, talked about your constitutional rights that you have in a criminal case, and then most likely set your case for a next court hearing and most likely a pretrial conference. And most importantly, the court entered a not guilty plea on your behalf. And we'll come back to that later in the video about why that's so important. Finally, the court determined that you qualify for the services of the Public Defender's Office. The judge's decision set a number of things in motion behind the scenes. And in a nutshell, here's what happened as a result of that decision. Right after your initial hearing, the court notified the Public Defender's Office of a new appointment. And then the Public Defender's Office decided that I would be the attorney who would be representing you in your criminal case. After that, they sent me notice letting me know that I had a new assignment, and then they ended up entering an appearance on my behalf in your case, letting the court know and the prosecutor know that I'm the attorney representing you. Then once I found out about the new appointment to your case, I opened a new file in my case management system, and then I prepared and filed a motion requiring the government to provide any evidence that it might have against you. Now, you might have heard of that motion referred to as a motion for discovery. The court will usually grant that motion immediately and order the government to provide its evidence to us within 30 days of the date of the court's order. At the same time I file the motion for discovery, I also file a notice to the court and to the prosecutor letting them know that we're demanding trial by jury. Finally, as the last step in my new client process, I sent you a letter notifying you about your next court date and letting you know a little bit about the process. And I also, if we had a good cell phone number, we sent you a text message, which is how you probably got this link. Now, once all of those things are done, behind the scenes, then there's a bit of a lull in activity. And a lot of my clients worry about that lull. And so I'd like to tell you a little bit about why that is so that I can put your mind at ease a little bit. But before we dive into that, it will help if you understand a little bit about the goals and strategy behind criminal defense litigation. So let's start out with what I like to call my don't ask, don't tell rule. Now, what that rule means is that at least at this early stage of the litigation, I'm not going to ask you about what happened on the day that the government's saying that a crime was committed. And I don't want you to tell me what happened on that day either. Okay, now there are two exceptions to the don't ask, don't tell rule. And the first exception is if you weren't where the government said the crime took place at the time it took place, then I need to know that right away. And then the second exception is if the crime actually occurred outside of the jurisdiction. So that's if crime actually took place in Clark County, but they're saying that it took place in Scott County. That's something I would need to know right away. So why is it that I don't want to know your version of events at this stage of the proceeding? Well, the answer to this question may just change the way you think about criminal law. Now, you remember earlier I said that the most important thing that the judge did at your initial hearing was enter a not guilty plea on your behalf. It's important because until a jury returns a verdict finding that you're guilty, or until you go into court and admit your guilt under oath before the judge at a plea change hearing, then to me, to the court, and to the entire world, you are not guilty. So not guilty is the default in your case. But wait, I can hear you thinking it right now. You're thinking to yourself, but wait, I committed the crime, so that means I am guilty. And here's that moment where you're going to start seeing things in a whole new light, in a brand new way. Okay, so even if you committed the crime and you know you did it, and you had no valid excuse, and you had no valid defense, even if all of that is true, you are still not guilty. And to think about your case, or any criminal case for that matter, in any other way is not the way to think about it. And here's why. You see, even if you committed the crime, Indiana law is absolutely clear on this point. The only way that you can be found guilty is if the government, the state of Indiana, is able to produce enough evidence to prove that you are guilty beyond a reasonable doubt. So at this early stage of the proceedings, I'm really only concerned about one thing, and that's what evidence does the government have to prove that you are guilty of what they're alleging you did. And nothing that you tell me at this stage of the proceeding is going to change what evidence the government has against you. And I can't really advise you on what the right thing to do in your case is until I know what the evidence is that they have against you. Now, let's talk about what you can expect to happen at your pretrial conference. So first things first, you have to be here at your pretrial conference. That means you have to physically be present and you have to be here on time. The Scott County Courthouse is located at 1 East McLean Avenue here in Scottsburg, Indiana. Now, once you've gotten to the courthouse, you'll go to the east end of the building, and that's the only door in which you can go. So you'll go up those steps and through that door, and once you get through there, there's a metal detector. You'll go through the metal detector, and then you'll go upstairs to the second floor. Then once you're upstairs, you'll go all the way to the opposite end of the building, and that's where the circuit court is. It'll be on your left-hand side, the doors to go in. So you can go on in and have a seat. The doors should open promptly at 1 o'clock. Now, if the judge is about to start a proceeding on the record, then he may instruct you to go to a different location to wait for the pretrial conferences to take place. And if that's the case, then just head to wherever he instructs you to go, and then I will come and find you later. Assuming that the judge isn't on the bench or conducting hearings in court, then I'll come into the courtroom and I'll introduce myself to everyone, and then I'll go through my client list and call names one at a time. When you hear your name called, just raise your hand so that I know you're present. So what exactly is the pretrial conference? What's going on then? Well, the pretrial conference is a time when I get to meet with the government's attorneys about your case. And we'll be talking about the status of the evidentiary disclosures. Have they complied with the motion for discovery that has been ordered? And then we'll be talking about the next step in the litigation process. Another thing that sometimes happens at that first pretrial conference is the state or the government makes an offer to resolve your case, sometimes even at this early stage of the proceedings. Then, after I get done meeting with the government's attorneys, I'll come back out to the courtroom, and this time I'll call names one at a time. And as I call your name, you'll come out into the hallway, and you and I will meet one-on-one and talk about the specifics about your case. So first and foremost, do you have new contact information? If for some reason you've moved or if your phone number has changed, I need to get that information from you, and I'll write that down and keep it in my file. If the government did give us an offer, then I'm required to tell you what that offer is so that you're apprised of what your options are. If you have questions, then this is the time to discuss them. Now, usually I'll be able to answer any question that you have. Now, if you have information that you think is pertinent to your defense, this is a time when you can give that information to me, and I'll put it in your file for when I need it. Number 5, I'll be providing you information about the next steps of the litigation process. Finally, you'll be getting a written notice regarding your next court date. So when you leave the courthouse, you'll know the next date and time of your next hearing. Now, you'll probably notice I typically have a lot of people on the list for every pretrial conference day. And that's going to raise a question in your mind, I'm sure, which is, how long will I be there for pretrial conferences? Pretrial conferences typically take all afternoon. And so what that means is that you and I will likely be there from 1 o'clock until 4:30. So I want to give you some tips about things to do or things to be ready for at your pretrial conference. So first and foremost, because of the time frame and the number of clients that I'll have set, you need to be patient. Bring something to read with you or something to otherwise occupy your time while you're there at the pretrial conference, because there'll be a lot of time where you're just sitting there and waiting. Another tip is, don't schedule things for that afternoon. If you have kids that need to be picked up from school, make other arrangements, because most likely, as I said before, we'll be there from 1 o'clock until 4:30. Plan for a full afternoon on your pretrial conference day. In terms of things not to do, I'd say don't go to the prosecutor's office and don't go to the court staff window and ask them questions, because they're not going to know what is happening in your case. Another thing not to do is don't leave without talking to me and getting your next court date in writing from me. Okay, now I know I just hit you with a lot of information, but I think we're ready now to go to the next video where we're going to talk about the things that you can do to help me help you be successful in your case. So click on the next video like you've done in the past now, and I'll see you in a few minutes.